dressing and repositioning the body. So you all are reacting to this, especially I'm sure the licensees, if you will, the regulators on the line here today, but you're also a licensee, so you have knowledge now to start to ask yourself, is this within the scope of practice? So the first issue we are going to think about is, well, who's responsible for interpreting that scope of practice? And when I say scope, just to be clear, especially for the new regulators on the line, is the scope of practice is going to be in the statute itself. It will be defined, and you all, as the regulators, as the board itself, are responsible for interpreting that scope of practice. You bring the expertise and public members to the table to, as a group, determine how to interpret that scope of practice. Now, that interpretation might be challenged in the courts, as would perhaps it in this case itself as well, and or ultimately will be challenged. But that is your role. Now, this takes us all the way back to the deference question. If you interpret something like you're reading on the screen now to be within the scope of practice, and someone challenges this, and it gets appealed eventually up into the court system, into the judiciary, does the judiciary give deference to you all as the regulators that you may have determined yes or no to this question? And again, a very, very important concept that I think that continues to, one, not only be potentially challenged, but at the same time will regulations looked at if the deference principle is either eliminated or diminished when it comes to matters appealed into the courts. So back to the case itself. This organization has been performing services since 2013, and they expressly note on their website that they are not licensed funeral directors. So again, we can all react to that now from a factual standpoint and say, what does that mean? Well, one, they're being truthful. They're not licensed. And are they actually potentially suggesting that they are licensed? Well, they will argue, no, we clearly say this on our website, and we tell people that we are not licensed funeral directors as well. So we are not, this group would say we are not under the control, if you will, of government, but for perhaps a business license or otherwise. So this is a case that will be interpreted under California law. It is in the federal courts, but it's a California law-driven issue. A funeral director prepares for the transportation, burial, and disposal of human remains. And by the way, I think there's a California person on the line or multiple ones. So if any of this is inaccurate, please type it in the chat, unmute. Let's get ourselves corrected here. But directs and supervises others who perform those functions, maintains an establishment for the transportation, disposition of care, or care of human remains, may use connection with his or her name the words funeral director, and we've already talked about this other organization says we are not funeral directors, we are not licensed, and must be employed by or be the proprietor of a licensed funeral establishment. So we have a bricks and mortar driven issue as an establishment license, and we have individual licenses are granted as well. So now we have a funeral director defined, and then we have the scope of practice itself. Okay, so you all can read this. I don't want to read this all, but engaging in or conducting or holding themselves out as preparing for the transportation or burial, maintaining an establishment, or using a connection, those words of funeral director. We are seeing more and more scope of practice issues challenged legally because of broad issues or broad language used in the statutes themselves. And the best example is human medicine. And the practice of medicine is an extremely broadly defined term, and you might say, well, gee, do physical therapies intrude upon that? Is there exclusivity in doctors, human medicine doctors, to do something? Chiropractic, or even veterinary medicine for purposes of storing and dispensing drugs and otherwise. And so this is back to you all as the experts interpret that scope of practice. So we have to decide here eventually is that scope being violated for purposes of the home funeral organization. So in November 2019, the California Board or Bureau, technically Bureau, issued a notice of citation and fines, so therefore they are saying you're engaged in the unlawful or unlicensed practice of funeral directing, and that you are then subject to potential daily fines, or however it's worked out, but in this case it's $5,000 per day. The board claimed that, or Bureau, the Bureau claimed that Full Circle was improperly holding themselves out and acting as, I probably should have put that in the slide, but acting as funeral directors, and thus they required a license. And so this is a garden variety strict case of are the activities undertaken by Full Circle, do they fall within that scope of practice? Apparently some informal negotiations were undertaken, and ultimately those must have been unsuccessful, and I'm giving you the information that I could garner, and again, if there's more out there, please feel free to chime in, but no one read too far into this, but the point is that they were unable to resolve it informally, so Full Circle eventually requested a formal administrative hearing, which they have a right to do, and here is where they would be heard in a more formal setting where they could confront those that were accused. They could present witnesses and evidence on their behalf and ultimately let a decision be made. As you can see here, $5,000 a day can add up pretty quickly, so there's a lot at stake for all parties here. And obviously the Bureau is suggesting the unlicensed practice needs to be stopped in the interest of public protection, and Full Circle is arguing that they are not engaged in the practice as defined. So before the hearing then took place that was requested by Full Circle, following their rights, before that hearing, Full Circle withdrew its request and initiated litigation in federal court. So that will raise a lot of legal issues. We're not going to get into the procedural sides too much, but that does confront, if you will, some procedural issues as to whether this entity, Full Circle, must exhaust its administrative remedies first before they jump into federal court and otherwise. And those were all argued eventually. But so Full Circle here alleged the First and 14th Amendment violations. So these are fundamental rights to free speech under the First Amendment enforced against them through the 14th Amendment by the California Bureau. So this becomes now a First Amendment-driven case to say, is this a free speech issue that's being infringed upon in an unconstitutional manner or not? And by the way, just quickly, the plaintiffs in this case not only included Full Circle, which engaged in the service, but it included multiple families who were the recipients of those services. So now we have a consumer involved saying, if you take away the rights of Full Circle, we won't get the services we expect. And so that will add an element of consumer perspectives to a matter, which will offset some of the economic arguments that could be made against Full Circle about they just want to make money doing this or anything else. So we do have plaintiffs that include both the practicing entity or the business itself plus the recipient of services. So these plaintiffs then sought a preliminary injunction preventing the Bureau from enforcing the Practice Act against them pending the outcome of the trial. And that trial ultimately would be on the merits itself, potentially. And that's where you would get into the nitty-gritty of the legal arguments. A preliminary injunction is an extraordinary remedy, and so you have to overcome some hurdles before you can actually enforce that itself. And here as I mentioned, yeah, go ahead.
Sorry to interrupt. Gina Sanchez from the California Cemetery and Funeral Bureau has commented a couple of things in the chat. I'm going to maybe ask you to pause for a moment and let her unmute and speak to a couple of things.
Excellent. Appreciate that.
Okay, just give me a minute here. Is my video coming up?
There you are. Yep, I see you.
You can see me? Okay, I can't see me. So if it's a little funky, I'm sorry. This is Gina Sanchez, hi from California. Yeah, I did not know we were going to be sharing all my business here. So I appreciate you bringing this up, and it has actually been informative. I appreciate that. I think The citation itself was for advertising, and that's what the investigation was. And through our investigation, they changed their website to reflect more of advice and adding that we are not funeral directors. So it was through our investigation that website was remedied. The citation itself was withdrawn due to it was functionally wrong at the time that it was written. So that's a whole other story. So really what they're attacking, they call it as a pre-enforcement, saying like you said, I agree that the statute is there's my camera, that the statute is very broad, and that's what they're really fighting, is that it's a very broad statute. They do get paid for their services where they go into the home and they, at first they were saying that they do the death certificates, do the transporting the body to the cemetery or the crematory and all that stuff. Once we have the discussions, it's now advice, and they help families do that. So it's that kind of fine line that we're really dealing with here. 7615 is definition of a funeral director. 7616 of the Business and Professions Code defines a funeral establishment, and that's where it gets even more broad. The statute of what you can do to assist people in dealing with death. As far as I know, we can't charge $5,000 a day for unlicensed activity. I'm not quite sure where that came from, but the maximum amount of a fine for unlicensed activity is $5,000 for each offense. So I just wanted to clarify that. I don't know of the law that would allow us to charge $5,000 per day. I guess if they kept operating and we continued to issue separate citations and separate instances of it, but in that case, we would refer to the district attorney or something along those lines. But yeah, we're continuing to go and work through this and really define scope, and so that's exactly what we're doing, is speech versus conduct and defining scope. So if anyone has questions for me or would like to actually see the case, it's a public document, and I can send the link.
Thank you, Gina. And sometimes my worst nightmare is somebody's on the line that's the defendant in a matter. So I certainly appreciate it. So if I get anything wrong, you stay right there and unmute and help correct me and make sure that we know up-to-date information.
Absolutely.
And since she did speak here as well, we learn from matters like this. This is an issue of the importance of a legal issue that can surface. And the conduct versus speech is relatively new, if you will, in the regulatory arena, and it does add an entirely new layer of legal analysis that comes up. And so I'm sure Gina and her staff and the attorneys are, obviously going to be well aware of how that might apply or perhaps not apply, the First Amendment and otherwise. And so it's good to know you're here, and now I feel like I'm going to tread even more lightly here. But again, we learn from this. This is not a critical issue. This is not to be critical. It's just an analysis that will provide us with some information. So
I appreciate it. Thank you.
Chime in when ready. So back to where we were. So we have a preliminary injunction, and that's just an extraordinary remedy whereby a party would say, court, do something today, and then pending the outcome of a trial on the merits somewhere down the road. And you have to overcome quite a few issues in order to have that preliminary injunction entered. And the defendants in this case, the Bureau, filed a motion to dismiss. So now we have kind of competing procedural issues. So as emphasized in the middle of the slide up there, there's no ruling on the merits. Okay, so nothing is decided yet as to First Amendment this or scope of practice that, and where they may collide related to and ultimately be determined conduct versus speech. So that likely will come somewhere down the road unless there is a resolution in advance. And in many times, in cases like this, there is a resolution in advance as well. So we will look forward to future issues on this. Very quickly on some procedural issues. This is legal nuts and bolts, but I just wanted to touch upon the bullets that are up there. The court held that the plaintiffs in this case we're not required to exhaust the administrative approach because of the fundamental nature of the rights at stake, free speech, First Amendment. It also ruled that the plaintiffs had standing to sue, so they were able to assert their rights, and that the matter was ripe for adjudication, even though nothing had been finalized yet from the standpoint of the citation and fines, and that ultimately the court did have subject matter jurisdiction to hear the case based upon a lot of those factors that we have up there. And then lastly, the Bureau was not entitled to the dismissal, which would be a procedural issue. So again, it still is pending, but it's pending from an issue on the merits. The elements of a preliminary injunction involve likelihood of success on the merits, irreparable harm, and public interest and balance of equities. This is how a court will look at something that says, should we decide it today and have a matter procedurally ruled upon pending the merits case somewhere down the road? And we all know litigation takes a lot of time, so the merits of this case may not be determined for months, perhaps longer as well. So they went through that argument itself and some of those issues, and the court found in favor, and here, Gene, I'll rely on you again to make sure this is current, found in favor of the plaintiffs and enjoined the Bureau from enforcing the act pending the outcome of the trial itself. Interestingly, the court, in the opinion itself, and again, this is from December 29th of 2020, and it is the United States District Court for the Eastern District of California, said that the Bureau did not identify any government interest or explain why the administrative action does not burden more speech than necessary to further an important issue. That's that fourth element of least restrictive means under the cases.
I forgot. Just.
All right. Thank you. So the issue now of ruling upon this on the merits will eventually surface and come forth, and as I mentioned, that may be a while. But the lesson to be learned that I got out of this, and again, with Gina's help, it helps me to have more information, but the lesson that I've learned from this is understanding how the First Amendment might have to be argued, and that we as lawyers on behalf of the regulatory community or your state boards themselves must understand that four-pronged strict scrutiny test we talked about, and make sure we address this issue of least restrictive means, because if speech is going to be viewed under the First Amendment, if the actions of an entity or a person are going to be viewed under under the First Amendment, that strict scrutiny will apply, and we have to make sure that we are very clear about the importance of the restrictions that are had in order to protect the public themselves. And so lots of words, lots of things that went on in this case, and that will ultimately go on as well. Gina's here to help clarify as well, and thank you for those comments that exist. And gee, while we've got somebody else, while we've got boards on the line here as well, and I'm looking at your attendance list, if anybody here is from Arizona, I think they are. Yeah. So Arizona, feel free to chime in as well on this one. I'm not going to speak too much about this, but I encourage everyone to read occasionally a sunset review report or audit from outside of your jurisdiction. It can be very, very enlightening. In November of 2020, the Performance Audit and Sunset Review Commission, I think they are in Arizona, issued its report on the Arizona Board of Funeral Directors and Embalmers. And again, this is not a critical issue. I'm not being critical of them, but these are great documents to identify where there may need to be improvements. Okay? And I view sunset reports, by the way, as extremely beneficial to the regulatory community. Okay? If it identifies something that's not working well, fine. It gives you areas to correct. If it identifies where things are working very well, it gives us something to look to try to improve our ability to enforce the Practice Act within any of the jurisdictions themselves. And so for those on the line here that don't know what sunset review is, there are various ways there, but it should be set forth in statute, and occasionally your board is under some kind of a review in order to maintain the fact that the profession should continue to be licensed. Okay? And so sunset reviews can be extremely important to say, If a board isn't doing its job or if it's not working well, perhaps legislative changes are made all the way up to including deregulating a profession. Okay, so these sunset reviews can be very important. Now, you can see the purpose of the Arizona audit to determine whether the board issued licenses to individuals and businesses in the funeral industry in accordance with statute and rule requirements. You all should be thinking like that every single day, every single board meeting, administrators and staff on the line every day, board members every month or whenever it is that you meet. Are you undertaking matters in accordance with the law? And that law can be a statute enacted by the legislature. It can be a rule promulgated by the board or a combination of the two. Continuing to read whether they conducted funeral establishment and crematory inspections as required. So if you all have a requirement to conduct inspections or audits or reviews as part of either renewal or periodic physical on-site inspections and visits, make sure you know what they say and follow whatever it is they are. And if you don't, you may be subject to some criticism, either in an audit report or otherwise. And whether the board provided responses to the statutory sunset factors. So if there are factors within your law, know what they are, and obviously follow them. Now, I will add to this that, in my opinion, whether you're under a sunset statute or not, act like you are. Okay? Hold your meetings, robust minutes, provide reports or annual reports and otherwise. And so kind of while I'm on that topic, if I may, and I know we're going to run out of time in just a few minutes, but invite people to your meetings. Let them see you in action. The regulatory community operates behind closed doors. No one really knows what it does. Sometimes I wonder if even the boards know what they do. And I say that somewhat tongue-in-cheek, but in part. So invite people to your meetings. I would send a letter to the governor's office before every meeting and say, here's the attached agenda, and we invite you to attend and see what it is we do. And when the governor does not attend, which the governor probably won't, follow it up with a post letter with the minutes attached, once those minutes are approved, by the way. And that means what? It's going to keep you writing accurate minutes that reflect what it is the board did. And I read a lot of minutes from board meetings, and sometimes, they need to be improved a bit. And I'm not speaking Arizona, by the way. I'm speaking now generally. And so if you're going to follow this, certainly write robust board minutes. And there's an art to that. Doesn't mean you're going to write down everything that everybody says and everything else. But when an outsider reads it, they should know what it is the board does and did at that meeting itself. And there are other ways to, again, I think, prepare for these sunset reviews, whether you're going to fall under them or not. So if you do this issue of keeping accurate records and robust minutes, it's easier to comply with sunset and audit issues that come up. And even if you're not under a sunset, I would attach the board minutes to some kind of a report and send it to the executive branch, the governor's office, or whomever, the appointing authorities, and say, look, here's what we did in the year 2020. And we did a great job at it. And promote yourselves so that the community has an understanding of what it is that you do, whether they're the appointing authority, the legislatures, the media, the academic community, or the consumers themselves. We need to be proud of what regulators do, and we need to showcase that to some degree, at the same time understanding that we might be under a sunset review as well. So in Arizona, they have some key findings and recommendations. I'm not going to go into those, but everyone should read sunset reports from not only your state, but others. And by the way, if you can't find any, contact me or contact the conference staff, and we can direct you to them. And you may want to read a sunset report outside of the funeral industry. It may be in vet medicine, it may be in human medicine, it may be in mental health, it may be others. And so these can be very instructive to ensure that we as boards perform as we should, and that we invite the scrutiny rather than shy away from it. Last couple of slides here, COVID issues. We can't leave a legal issue without talking a little bit about COVID, and we will discuss this a little bit more as well in the session to follow today, and the next session about complaints, and perhaps a little bit tomorrow as well. But As we know, there are executive orders all over the place, more executive orders than we've ever seen in the history of anything that I've researched, at least. And it's driven by COVID and the reaction to and everything that's happening. There are thousands of executive orders and there are websites where you can find them. These are at the state level, by the way, state-driven, governor-issued executive orders, and there seemingly are thousands of lawsuits that are challenging these. This pandemic has gone on long enough where likely, in my opinion, almost every executive order that is going to be granted in the future is outside the bounds of separation of powers. We have a legislative branch that enacts laws. We have an executive branch that enforces laws. Judicial branch interprets. And this has gone on long enough where the legislatures have time to meet and address these issues. And that's a lot of what the litigation is about. We don't need to get into the details of it, but ultimately, some of these issues may be struck down. This is an example of the state of Michigan and Governor Whitmer's executive orders basically being struck down because the court ruled that the governor doesn't have the right to continue to effectuate an emergency declaration and then issue executive orders to dictate what can and cannot happen in a business sense. And so here in Illinois, our governor every 30 days renews the emergency order and continues to issue executive orders. Is that the appropriate way? It may or may not be. But the point of all this is this COVID is changing issues related to the legal aspects that do come up. Tomorrow in the board training, we're going to cover a little bit more about COVID and a little bit more detail about some of these that exist as well. But Lauren, any other comments or questions that are coming up? And the reason I tease you with tomorrow is to get you all to come tomorrow. So we have some of those opportunities as well. Because my next slide is the big thank you slide as well. But let's identify if there are any questions or make sure Gina is still with us. Gina, are we okay with everything I said? So.
I don't see any other comments, Gail. Arizona is on if they have anything that they want to add. Other than that, the link that Gina referenced, some of you have inquired about that, and she is going to go ahead and get that to us. She's trying to locate it now. Oh, there's Judith. Judith Stapley, Gail, is the Executive Director of the Arizona Board of Funeral Directors and Embalmers.
Excellent. Hey,
Hi, Gail. Hey, I didn't want to take up too much of your time, but just to enlighten everybody just a little bit on that. The auditors, it was an interesting experience going through the sunset audit. They ultimately did recommend that the board be continued, that it would affect the health and safety and welfare of the public if we weren't here. So that's a big yay. That particular slide that you showed, so I wasn't with the board for the previous sunset audit. Everything that they claimed we weren't properly vetting before licensure with establishments, it was that you say you already owned an establishment and a percentage of the ownership changed or it was sold, but it was still there. We didn't always go out and re-inspect that establishment. And so because it was technically a new license, we had to always inspect. So that was one thing they brought to our attention and dinged us on. And then with the individuals, again, if you really read the law, every time somebody applies for a license, we're supposed to collect a fingerprint card and charge them and run their fingerprints for a background check. How the board had been handling it when I walked in, and I didn't see an issue with it that I should have, I guess, is that if you're already holding, say, your intern license and now you're applying to be an embalmer, we had to run your prints again. And their argument was, well, you're not protecting the health if you don't run the prints every single time. So say you're holding an active embalmer license and now you want to be a cremationist, we should run those prints, which to me seemed overburdensome when they were explaining it like that. And I said, well, if your point is to protect the health, safety, and welfare of the public, I could have been licensed in 1976 and renewed every year, and we have no statutory authority to redo your background check. So that's something that needs to be looked at. But nonetheless, the report looks like we weren't vetting or checking anybody. So I just wanted to throw that out there.
Excellent. And again, these sunset reports or reviews or audits, whatever they're called in your jurisdictions, basically will never find that the board is perfect and doing everything they should. So you get used to this. And if there needs to be improvement, that's okay. You take advantage of that, especially ultimately, as Judith said, they recommended that the regulation continue, which is fine. And so this is why I'm suggesting you read these reports and say, oh, wow, do we do that or not do that? And we all learn from each other. So I bring up the California case, I bring up the Arizona issue, so we can learn from it, that's all. And so, again, thank you, Judith, for some of those details. As I mentioned, it's always nerve-wracking to know somebody's on the line that can give me more details and everything else. And so I try to be, obviously, as accurate as possible. So,
thank you, Dale.
And to end with a little story related to that as well, by the way, is I used to pick out funny cases that I thought may have nothing to do with regulation, and I would just get the audience involved in legal issues by bringing up a funny case. And this is a live presentation in front of an audience as opposed to virtual like this. And someone had wanted to change their name to Santa Claus. Okay? And it went all the way up to a state Supreme Court. I will leave the state out of this. And I brought that case up just to bring light to a case, try to make people laugh and get us all warmed up to legal issues. And a hand shot up in the back about the case, and I didn't talk much about it other than to, just bring it up. And the person said, that's my brother-in-law. And so they told us all about the case from the audience as well. And so I've learned to make sure I defer to anybody in the audience that wants to talk about any of the cases I bring up. So in conclusion here now, not too many cases have matriculated into the court system. It's good and bad. That conduct versus speech, extremely important. We keep an eye on that issue, learn a little bit more about it in the First Amendment. The audit bringing up, again, so we keep an eye on them, read them, and learn from them as well. And people like Judith can talk about it. The process and the content that came out of it can be extremely important. So hopefully the last 60 minutes here has been enlightening to everyone related to some of the legal issues and the trends that are out there. We will talk more about some of these issues in the board training tomorrow. Very little overlap, and then with some of the legislative updates tomorrow afternoon as well. But Charles, I will turn it back to you with a big thank you for what you do and you're presiding over this meeting, and to everyone on the line for the important role you play in public protection as well.
Thank you, Dale, and thank you once again for a wonderful session there on legal updates in 2021 and the do's and don'ts. And I will attest to you, because I am a Sunset Board agency, that it works. I do not see the Sunset Committee as some people view them as the enemy. However, if I'm doing something wrong, when they point it out to me and give me the opportunity to be corrected, it just makes us all better. So I really agree with your comment, Secretary on the Sunset Committee. But thank you for all that you do. At this time, we're moving right along.